I often have said to juries in trials that it's not really the defendant who is on trial. And that often gets a surprise look from people because really the party that's on trial is the government, the state, the prosecuting body that is bringing the accusations against the defendant. The jury's job is to judge the government and whether or not they met their burden of proof beyond a reasonable doubt that the defendant is in fact guilty. And if they failed to do so, then the presumption of innocence holds, and the defendant who started the trial as an innocent person finishes the trial as an innocent person, and the jury is expected to return a verdict of not guilty. So basically, the presumption of innocence is a rule that says that we don't punish people for having broken the law in a criminal sense unless it is proven beyond a reasonable doubt that they are in fact guilty. Now, a defendant can convict themselves by pleading guilty, by admitting guilt, and basically waiving his or her right to force the government to prove their guilt beyond a reasonable doubt. That's what happens with plea agreements, for example, which are the most common way that criminal matters are resolved here in the United States. So the presumption of innocence is one of the most, if not the most important principles of our criminal system.